Okay. So welcome to the first session of the morning as far as the live presentations. I'm excited that we're back in person again. It's been a few years since we've done this transition fair live and in person. And quite honestly, I like it so much better than Zoom. Zoom is a wonderful thing, but it doesn't give that same sort of interactiveness and that vibe that you get particularly when you're a speaker. So I hope you guys are all interactive with me today, because that's the way I like to do it. So with that said, as I'm going along, if people have questions, I do try to take the questions while I'm talking. I might not get to all of you because I do also need to keep things moving along so we don't completely run out of time and I don't get to why you're here. But I will try to take questions as we go along, so just put your hands up or interrupt me or wave wildly or whatever, okay? A little bit about myself. My name is Jennifer Stenberg, and I'm one of the attorneys with the Dale Law Firm. We're a small law firm in Contra Costa County that specializes in working with families that have a disabled family member. And because of that, a lot of the families we work with are parents, I'm imagining much like many of you here in the room, with a child, son or daughter, with some sort of a disability. And we do estate planning, so we focus on special needs trust planning, and Steve, my colleague, is going to be talking a little bit about trusts and other forms of planning for people with disabilities later today. And then we also do limited conservatorships in both Contra Costa and Alameda County. So that's why you guys are here. Partly why you're here this morning is to learn about legal decision making for persons with intellectual disabilities. My background is that I actually have an adult sister with developmental disabilities. She lives in a supported living arrangement in Emeryville, and she receives 24/7 support. My father, who is now quite elderly, and myself are her co-conservators, so I understand conservatorship both from a professional standpoint as well as a family member who's kind of in the trenches dealing with all the day-to-day things that come up and why conservatorship can sometimes be necessary and important. All right, so let's get started. And of course, my clicker is not working. Steve. All right, good old-fashioned buttons maybe work. Let's try those. Nope. Well, I'll just talk. We don't need a PowerPoint. Oh, there it's. Okay, now it's working. Okay. Okay. You got the magic buttons, I guess. All right. First thing is, why are we all talking about legal decision making at a transition fair? Well, partly because at age 18 is really the critical time in a person's life when they're transitioning from being a child, for lack of a better term, to an adult. And in the state of California, and in most states across the country, 18 is an important legal age. It's the time at which the government, through our laws, consider a person to be their own legal decision maker. All of the rights of the parent, who was the custodial parent, had legal ability to make decisions for that minor child, evaporate on that day of the 18th birthday, and suddenly we have a person who is recognized by the law as being fully able to make all of their own decisions. And that is quite honestly regardless of whether they effectively can make those decisions for themselves or whether they need some support. There's a presumption under the law that everyone who turns 18 has what we call legal capacity. So that's why 18 is kind of the time when we really start talking about this and when many families are starting to think about what do we need to do. Does my son or daughter need some continued assistance, or are they going to actually need someone to be able to make decisions for them? So that's what we're going to cover a bit today. Under the law, the mere diagnosis of some form of disability or medical condition is not enough to determine that somebody lacks capacity. The government has a functional kind of assessment that they're supposed to rely on that's set out in the statutes that govern these sorts of issues. So again, the mere diagnosis of an issue or of a disability is not going to get you where you need to be to establish that someone lacks legal capacity. Things to think about when you're considering how to move forward with decision making for your family member. include the fact that, and this is really kind of we're going to talk about the continuum of options that are available, but you really have to think of it that way as well. A person with a disability who can't make their own decisions, they don't have the legal capacity to do that, nor can they communicate those decisions, is going to be someone where light show, where conservatorship is probably going to be appropriate. But not all people with disabilities have that need. There can be folks with disabilities that can make their own decisions. And if that were the case, then you wouldn't need to be sitting in this room with me. There's also going to be people, much like maybe some of the people that we saw in the introductory video, where they obviously can make decisions, they can articulate for themselves, they can communicate their needs, their wishes, their desires very clearly. So perhaps for them, again, conservatorship definitely would not be appropriate, and some of the other tools I'm going to talk to you about may not be necessary. So you have to think about it in this continuum, and you have to look at what's right for your son, daughter, family member. Okay, there's a variety of tools that are available to assist with decision making for a person when they're an adult. Some of these tools, many of us in the room probably already have in place for ourselves. One of those is a power of attorney. Power of attorney is a document that allows you to work with other people in the area of legal decision making. Similarly, an advanced healthcare directive. It allows someone else other than the person themselves to be involved in decisions with regards to health care. So those are tools, and we're going to talk about them in more depth in a minute, that might work well for some of you here and the family member that you're trying to support. Another method, and this is kind of a new method in California, although it's been around in other states for a few more years and has some history and a bit of a track record. This is something that we're really just starting to develop here. Our statutes on this just went into effect about a year ago. So it's a really new tool, but it's called supported decision making, and I'm going to talk to you about what that is and how that works as well. And then finally, we have limited conservatorship, which is a form of it's a legal process where we can shift decision-making authority from one person to another. And in the case of limited conservatorships, it's when we're dealing with a person with a developmental or intellectual disability. Okay, I'm going to start out with powers of attorney. And the reason I'm going to start out with this is because much like them themselves, they're fairly straightforward, it's quick and easy, and it's not going to take up a lot of time, and I want to save our time mainly for the conservatorship part at the end of my presentation. But powers of attorney are basically written documents where a person can designate or decide who they want to have make decisions for them, and that could be if they can't make them themselves, or if they just want some assistance and they want somebody else to be able to work with them in a decision-making environment and process. Through a power of attorney, you can basically grant to the agent, the person that you're authorizing to act for you, many different kinds of powers. These documents can be extremely broad, or they can be very narrow. They're very customizable, and so they're a nice way of setting up situations where someone can say, I want my mother to be able to make decisions for me with regards to these things. And it can be as I said, very limited. Maybe it was one or two areas, or it could be very broad and cover almost all aspects of someone's life. Okay? So again, it's a nice document because you can make it personal and personalize it. A power of attorney does not prevent the person who's giving this power. So you have to keep in mind that power of attorney is really just a voluntary means of saying, I want someone else to make decisions for me, and I'm giving them that power with regards to my life. Okay, so it's a voluntary situation. So because of that, the power of attorney, when it's in effect, does not prevent the person, the principal as we refer to them under the law, from making their own decisions. So the disabled person still can make decisions for themselves. They're still legally valid, binding decisions. They're just saying that in addition to me making decisions for myself, I'm granting the same power to my mother, my father, my friend, whoever it is that they're appointing under the document. The other thing to keep in mind with the power of attorney is that a power of attorney can be revoked by the person who's granting the power. So what that means is if your son or daughter executes a power of attorney granting you authority, they can take the power away as well. So you have to think about that in the context of, is this something that's going to work in my situation?
It doesn't make any sense to me if the person doesn't have any limitations, then what's the power that the power of attorney is granted to someone?
You mean the person?
The principal. There's no limitations on the principal's decision making.
Right. So it's a document where basically a power of attorney would authorize someone to make a decision in their absence, or to make a decision maybe while they're there, but to articulate the decision for the person. It's used by family members, when you need to call. I'll give you an example. You're working with the case manager at Regional Center. Probably not the best example because under the Lanterman Act you could talk to them anyway, but pretend you couldn't. Under a power of attorney situation, you would be free to call the case manager, have a conversation with the case manager, and the disabled person themselves wouldn't have to be part of the conversation.
They wouldn't have to authorize you.
They wouldn't have to sign the release every time or do any of that. Yeah, okay,
Well,
yeah.
if I
Again,
can
it's a
add
tool.
just another comment, I'll try to be more, but a common one, we saw Liz, who has a developmental disability, but clearly competent. Well, maybe it's hard for her to sign documents, or maybe it's hard for her to do a number of things. So this is a way where you can delegate that.
Right, that's a very good example. So yeah, these types of documents are frequently used with people who maybe have full legal capacity, but they have difficulties with communication or difficulties with mobility, so it's hard for them to get places. So it can be a very useful tool in those situations as well. Yeah, okay. I'm sorry, did you have a question? I saw your hand sort of go up. Okay. All right. The other thing is that powers of attorney are readily they're readily usable in the community because, again, they're very familiar to people. Many of us, as I said, as part of your general estate planning, if you have an estate plan in place, you probably already have a power of attorney for yourself. Most likely for married couples, you've appointed your spouse or an immediate family member as your agent. So this is really no different than that. It's just that you have to think about it a little differently because most of us have them for when we are older and maybe start having some cognitive difficulties of our own. So it's future looking. Now we're doing it for someone where we're probably going to need to use it right away and immediately. Okay? All right. The other thing, and I should have said this at the beginning, the other thing with regards to a power of attorney is that in order for it to be effective, the person with a disability has to understand it, has to realize that by signing this document, they're giving this power to the person that they've authorized. So it won't work for someone who doesn't have the ability to understand that concept, that they're giving this power away. Okay? Yeah.
So how is that determined?
How is that determined?
Who will determine it? Whose determination is accepted by the state?
Right, it's a good question. So it's somewhat of a subjective sort of determination. In the law, what it says is that someone lacks legal capacity if they cannot understand the nature of a decision that they're being asked to make and the consequences of that decision, or they're unable to communicate the decision effectively. So that's the legal standard. Now, what does that mean? Again, it's somewhat subjective. It's not a clear-cut decision. When you're using a power of attorney, because it's not a document that's going through a court proceeding, it's a voluntary contract that two people are entering into. The question of validity comes up when you're presenting it to someone to try and use it. And if somebody challenges it, then they can refuse to accept it. If they do, then your only recourse would be to go to court if you needed to try and compel the decision. And then you would be going through a court process. Now, I will tell you, my experience is that people don't question the validity of powers of attorney very often. And in fact, they probably don't even really understand that they can. Because many people, if they're presented with a power of attorney, will just say, oh, well, this person then is the right agent, and they'll just accept it. And that's not a great legal answer to your question, but that's the more practical answer to your question. It's very rare for people to not accept them.
Right. I mean, if I were to come to your office, would you take that, bring my daughter or whatever, and would you like, okay, take 5 minutes to ask those questions and determine if she has
Yes.
the capacity or not, and you will let me know, probably in this case,
Yes.
you know, you probably want to go for conservatorship. Or
That's exactly what we would
can
do.
have somebody,
Yeah.
like a legal person,
Mhm.
evaluate that capacity.
Right. As a lawyer,
Other than
because
yourself.
I'm an officer of the court, I'm actually ethically bound to not assist someone enter into a power of attorney if I feel they don't have the capacity to understand it. So that's exactly, if you come into my office and you were meeting with me and you brought your daughter in your case in, I would sit down with her one-on-one and I would have a conversation with her for, again, usually 5 or 10 minutes. And just kind of make my own assessment. And there's kind of a series of questions that we usually ask, standard sorts of questions. And if the person can answer them appropriately without coaching from someone else, then usually we'll say, oh yeah, okay, this person has capacity, we can go forward. Amy?
Do you have to have an attorney help you
No.
do a POA?
You do not need to have an attorney help you do a power of attorney. These are documents that are readily available. You can download California actually within our law has what's called a statutory power of attorney, and it's a form. You can literally go on to the internet and Google it, and the form will pop up, and you can download it, fill it out, and have the person sign it. It does need to be notarized, so there is at least that level of formality to it, but it's a very simple, easy document to create. What I will tell you is that if you work with an attorney that's experienced in this area of law, like our firm, we have a power of attorney that we've developed over time that's going to specifically address some of the particular areas of decision making that come up for family members with intellectual disabilities. We've got a whole section that talks about working with regional center, a section that talks about working with community service providers, residential care providers, supported employment, all of those things. The government, we've got sections that talk about dealing with Social Security, Medi-Cal, Medicare. So we've embedded a lot of those sorts of things in the tool that we use. But you don't have to use that. You can use one of the standard California statutory forms, and that'll probably get you 95% of the way there. Yeah, okay. Yeah.
Jennifer, do you have a recommendation for the person who's going to be the agent for the power of attorney in relationship to the trustee for a third-party special needs trust? Do you tend to separate those, or do you want to have the same person doing that in terms of like real world?
Right. It really just depends on the situation. It depends on what the makeup of the circle of support is for the disabled person. Many times we'll have a special needs trust, and particularly, if it's currently funded while the family's still alive, maybe that's being managed by a professional fiduciary, particularly if it has a lot of money in it. So that's being handled by more of a money manager. Whereas a lot of the decision making that you would be doing under a power of attorney are more personal. It's like, where am I going to live? What services am I going to take advantage of in the community? Those are not necessarily the sorts of things you want a financial expert to be making decisions about. So the agent under the power of attorney more likely is going to be a family member or someone who's close to the disabled person. They do not have to be the same person, and many times they're not, but they could be. So in the same vein, maybe you as a parent are managing their special needs trust and you're also the agent under their power of attorney. So it can work either way, and it's just kind of whatever makes sense for the disabled person, who's best in the two different roles. Okay. All right, I'm going to move on to advanced healthcare directives because they're similar to powers of attorney. Again, we've been talking about a power of attorney, which is a document that allows you to make decisions, and as I said, very broadly, but it doesn't cover medical decisions. So they've kind of carved that out in state law. And for medical decision making, when you have someone, again, who has capacity but maybe needs some continuing assistance and support in making decisions in the medical field, you're going to use what's called an advanced healthcare directive. Just like a power of attorney, the person executing the document, giving you that decision-making authority, has to understand that's what they're doing. They have to have that base level of capacity. And just like a power of attorney, it's going to be revocable, and we're not taking any of their personal powers away. So they're still going to be able to be involved in the decision-making process. They can communicate to their doctor what their wishes are, and they can override the decision of the agent under the Advanced Healthcare Directive. So, you got to keep in mind that if you go to the doctor and the doctor says you need this procedure, and the disabled person says, oh God, no, I don't want to do that, and the parent says, well, I think you should do that, let's do it, their decision is ultimately going to be able to trump the decision of the agent or the person under the advance directive. So again, it's not a move of power from one person to another, it's a sharing of power, and the person with a disability ultimately always remains in control. Okay, in addition to just the decision-making power that you can get through an advance directive, the advance directive also allows the person to articulate their wishes with regards to things like end-of-life care, as it says here, organ donation, other types of medical treatment can be discussed in this document, and there are sections for that. So it is a bit broader than just saying this is the person who's going to make medical decisions with me or for me. So it's a useful tool as well because it helps map out how the person wants the future medical treatment to be administered to them. Again, I've already mentioned an advance directive is going to be revocable, so it can be revoked or changed at any time by the person with a disability. Also important to know that there are certain things that an agent under an advanced healthcare directive can't do. You can't make decisions or give informed consent for certain types of treatment. They're listed here. I think if you read through the list, you'll see they're all fairly controversial somewhat, and the sorts of things that, you know, the decision on these is pretty significant, so we're not just going to give it away to someone through a advanced directive. It's going to involve a little bit more work with the doctors before you'd be able to pursue any of these. Yes?
Quick question, is there an assumption under an advanced healthcare directive that medical records be shared with that person, or does that always have to be okayed by the principal?
Good question. So release of medical information, it's a huge deal now, particularly every time I go to the doctor, they ask me if I have, they talk about the HIPAA, which I always think of hippo, but HIPAA. And so, yeah, they're very conscious of that. There is a section, there's a little paragraph in the advance directive that's basically an information release. If you were to work again with our office, we would also do a full-fledged HIPAA release form, and we'd have the person sign that, so that works in conjunction with the advance directive, authorizing whoever the agent under the advance directive is to have access to all medical records, as well as be free to communicate and talk with all medical providers about the person's medical treatment. Yeah, okay, so that's kind of the first area of possible decision-making authority tools is advance directives and powers of attorney. And I would say that that's probably at the, it's at one end of the spectrum of legal decision-making tools that we have. Again, it's going to work with someone who's got full capacity, understands the nature of the documents they're signing, but just wants or needs some continuing assistance and support, and that this is going to facilitate that sort of a relationship. The next tool that we have is what's called the supported decision-making. And the concept here is that this is a way for a person with a disability to choose certain people, and it can be one person or it can be more than one person, it could be a small group of people, but it's basically a team that's going to work with the disabled person to assist them and help them make decisions, as well as then implement the decisions that have been made. Now, the decision ultimately always has to be made by the person with a disability. So again, in a supported decision-making arrangement, the person with a disability has to have some ability to make a decision and to, let the support team know that this is their decision. So there's still a level of capacity that's necessary for it to be effective. But again, it's somewhat of a subjective determination as to what is that level, and how much support does this person really need before we get to a point where the decision is no longer really being made by the person, it's being made by the team. Again, important to keep in mind that the people on the team are chosen by the person with a disability. So this is you can't kind of assert yourself into the team without being asked to be part of the team. Okay, yeah.
So I'm assuming that's also a legal document that gets drafted?
Yeah, there's a contractual document that's going to formalize all this, and we're actually going to talk about it right now. Good segue into the next slide. So the person with a disability and the chosen supporters, the term that we use in the law is supporters, are going to enter into a formal contract. And that contract is going to need to list the areas in which the person is asking for the support of the supporters. So it's going to detail the areas of kind of decision making that the contract covers. And it's going to state that the supporters are eligible, and what that means under the law is that they're people over the age of 18, and they can't have certain things on their record, so to speak. They can't have, some criminal activity and things like that. It's kind of particular. But generally, it's pretty much anyone that the person chooses over the age of 18. But they do have to state that they're eligible and that they will support and implement the direction, will, and preferences of the person with a disability. So again, you can see that the language of the statute is very much promoting the idea that the disabled person is making the decision. They're just looking to the supporters to kind of help guide them, as well as help them implement if we've got a communication or implementation concern. Okay. The supported decision-making agreement can have some kind of standard areas in it. These are the ones that the probate code actually calls out as being appropriate areas of decision-making that should or could be included in the agreement. And you'll see that they cover pretty broad aspects of life. And it's kind of hard to think of things that aren't necessarily going to fall under one of those categories. So again, the idea is that the document, the contract, can be very broad. It could cover lots of areas, or it can be customized and just focus on one thing. So you could have a supported decision-making agreement that's put together, and maybe the only thing it covers is medical and psychological treatment, and none of the rest of the stuff is there. It could just be one area of life. You can also have multiple contracts. So a person with a disability could have a contract with one or two people to deal with their financial stuff, and they could have a separate one that deals with their medical stuff, and it could have a different group of supporters. So again, the idea is that this is something that's driven by the person with a disability and can be very customized to what they want and what they need.
It seems as though this could supersede the other two agreements, the power of attorney and the
Absolutely.
directive. So they would be lumped into one agreement, which would be this one.
Right. So when you're doing a supported decision-making agreement, contract, you probably wouldn't have those other two tools. You could, but you're right. They're kind of redundant. So the idea is that it's an either-or.
I see.
Yeah. Yeah. Okay. All right. The agreement also needs to be reviewed and updated on a regular basis. The law calls for that to be done every 2 years. And it can be terminated by the person with a disability. Now that seems pretty obvious. This is something they're creating for themselves. It can also be terminated by all of the supporters. So you can't just have one supporter terminate the agreement if there's multiple supporters. It has to be unanimous on the side of the supporters. The term of the agreement can also have an end date. So again, it's possible to do one of these contracts for a very specific purpose, and it might be a short-term purpose. So it could say that this is going to be in effect for 6 months until this task is completed, and then it terminates. So that can terminate by the terms of the agreement itself, or the obvious one, unfortunately, if the person with a disability dies, then the document is null and void at that point. Yes?
The first bullet point, is that a recommendation or is that a regulation that it has to be?
It's actually written in the probate code, where this law has been put into statute, that in order for it to be valid, it does need to be updated and reviewed at least every 2 years.
Does it require a presence or supervision of an attorney?
Again, there's nothing that says you have to hire an attorney. It could be done informally, just amongst the group, as long as it complies with the requirements of the law for it to be valid. Yeah.
But the other two agreements don't have this stipulation. They're forever.
No. Right. A power of attorney and an advance directive, once they're signed, they're valid until the person dies or they revoke it. There's no requirement that it be reviewed on any sort of regular basis.
Is it better to have an attorney do it legally?
You're asking an attorney that question.
It
It's just a question of cost every 2 years.
I would suggest that maybe at least the initial contract be done maybe with some input or supervision of an attorney, just to make sure that it does actually comply with all the statutory requirements. Do I think you need to have the attorney involved every 2 years when you're updating it? Probably not. At that point, I think you just meet and talk about it, and if it's still valid, everybody re-signs it and redates it. Yeah.
Does it have to be notarized or something?
No, no requirement for it to be notarized. Yeah.
Do we have a sample form for the NPM or is it just?
I don't have a sample form in my materials, but if you reach out to our firm, I could give you some, and there's many, many available on the internet. Because again, supported decision-making's been in place in a number of states for several years now. Texas has had it for, I don't know, a decade or so? A while. And so there's lots of tools that are out there, and there's a number of disability groups that have put together kind of templates that you can use. I think the ARC might have one on their national website.
I might mention this. I do the last program of the day, and we're going to have Sheridan Nicolau with the State Council. The State Council is all over this, and they actually have all sorts of programs they're putting together and workbooks and that kind of thing. Righteously, they're very much pushing supported decision-making in this whole thing, and if the person has capacity,
Yep.
good option.
Yeah. Yeah.
So we get all this documentation written up that they run online by the state, we have to redo this whole process.
Well, yes and no. So if you have one that's written in California and it complies with California law, there may be some slight variations from state to state, but I still think it would probably be pretty portable. But it would probably be prudent at some point to have it reviewed by someone in that state just to make sure it's still valid there. Yeah. But again, the laws are fairly consistent from what I've seen. It's not, they're not recognized in every state though, so I will say that. You need to kind of know which state, because again, California has just passed their statute within about the last year, whereas Texas has had it for quite a while. There's a few other states that have had it for a while. Some other states have not implemented it yet, so you just kind of have to know. I will say also, and this is just my own, I don't know, editorial comment, I guess, because it is new in California, and I'm not saying this to dissuade you from trying to use this tool, but do be aware that people that you then try to work with in the community may not, they're probably not going to be familiar with it yet. And so you might find you get a little resistance. So if you walked into a doctor's office and you've got one of these agreements for medical, the doctor's office is probably going to look at you like, what's this? A hospital similarly might look at you and say, we have to have our legal department look at this. We have no idea what this is. So because it's just so new, people aren't familiar with it yet, and so you might have some of that resistance. But hopefully as they get, more familiar with them, that'll go away and it'll get easier. Because I do think it's a valuable tool that for the right people, this is a really good option. Okay. Conservatorships. Now we'll get to the meat of the presentation. Yeah?
What if the person is not in the position to make their own decisions?
Conservatorship then is probably where you're headed, yeah. So when a person with a disability has a disability that's significant enough where they really just don't have legal capacity, they really can't make an informed decision for themselves, then unfortunately conservatorship is really the final available tool that we have available to us. A conservatorship, unlike the other two tools that we've talked about, a conservatorship is a formal legal proceeding. It requires you going to court. There's going to be judges involved. There's going to be court staff involved. There's going to be attorneys involved. So it's a much more rigorous sort of process. It's going to take more time to effectuate and to put into place. I'll tell you right now, if you're in Alameda County, where we're all standing today, you should anticipate at least 6 months to get a conservatorship in place. The court, unfortunately, is just very backlogged, and that's how long it's taking these days. So you need to plan accordingly, and we'll talk about that in a minute. I've got a little slide on when should we do this. But a conservatorship, again, is a process where a court is in essence, making a determination that a person with a disability lacks legal capacity, and therefore the court is going to grant legal decision-making authority for that person to someone else. In its essence, you're taking away the individual rights of the person with a disability. They are no longer legally able to make a decision for themselves. You're granting that right to exercise that legal decision-making power to someone else. Because of that, it's a very serious proceeding in the eyes of the court. They do take it seriously, and that's part of the reason why it takes 6 months, because they're gonna review these applications pretty thoroughly. To establish the conservatorship, the very first thing you have to establish for the court is that the person with a disability is unable to make or communicate decisions or understand or appreciate the consequences of the decisions that are being made. That's, again, as I mentioned earlier, kind of our threshold standard for capacity. And in order for a conservatorship to be effectively granted by the court, they have to determine that that person involved does not have legal capacity, cannot make a decision for themselves. If the person can, then it's going to be very difficult to get the court to grant that. About the only time they will is if the person that's disabled asks them to, and sometimes that happens. Sometimes we do have people that for whatever reason, even though they can make decisions for themselves and may have a level of capacity, they feel more comfortable having somebody else make decisions for them, and they can voluntarily request a conservatorship. Yes?
Is there a general stat of how often do those get turned down at court?
The ones where the person themselves is asking for it, or?
You go to get, a conservatorship and the judge turns it down.
It's not super common. I think because before you get before the judge, you've kind of gone through a couple levels of determination already. I mean, if you're working with an attorney, hopefully your attorney has kind of already made an assessment that this is an appropriate thing to do for the person involved. So that's kind of one level. There's going to be court investigators involved. There's going to be the regional center. If it's a person with an intellectual disability, they're going to be involved. So there's a lot of people that are going to give voice to this before it even gets to a judge. So sometimes that stops it. I will say that I think that the tides are kind of changing right now. If you had asked me that question 2 or 3 years ago, I probably would have told you it's very, very rare for a conservatorship to be denied. Because of a lot of media attention that's happened, I'm sure you all know who Britney Spears is, and because of the situation with her conservatorship and those proceedings and them getting so much media attention, that the legislature has looked at that. There have been a number of bills that have passed that have reformed conservatorships, and the courts now are looking at them much more stringently than they used to, which in many ways is a good thing. I'm not here to say that it's a bad thing. But it has made it, unfortunately, a little bit more difficult for families where it's the appropriate thing to do. But you got a couple extra hoops and hurdles to jump through. So my expectation is we are going to see probably a few more than we used to be denied, particularly where it's kind of questionable as to whether it's the appropriate thing to do. And quite honestly, if it's not the appropriate thing to do, it shouldn't be done. I mean, we should be using those other tools that we have available to us. Yeah, there was a question in the back.
I want to know what happens to the conservatorship if the parent passes before the child?
So that's a good question. I actually got a slide on that, but just briefly, if the question was for those of you who may not have heard it, what happens to the conservatorship of the parent, assuming the parent's the conservator, dies before the child does? Technically, in a limited conservatorship, which is what we're talking about today, if the conservator dies, then the conservatorship is terminated. But in practical terms, what happens is the court will then seek someone else to replace the parent. And so there's usually a follow-up proceeding because the courts don't want these things to just terminate. If the person needs a conservatorship, the court it would be remiss if they just let the whole thing kind of fall apart. Yes?
The conservatorship doesn't allow for alternative second and third person to be nominated, just like in a power of attorney. Does it allow or does not allow?
It doesn't allow a succession, but you can have multiple conservators. And again, we're going to talk about that in a minute, so I'll get there. Okay. All right. In California, we have 2 types of conservatorships. Well, actually, we have 3 types of conservatorships and then 2 categories of conservatorship. So we've got general conservatorships, which are the types of conservatorships we use for older people or people with mental health disabilities, behavioral health disabilities. And they're kind of an all or nothing. When you apply for a general conservatorship, the court grants you all powers with regards to that person or no powers with regards to that person. It's an all or nothing sort of proceeding. Then we have a limited conservatorship, and that's what that's what we're talking about today. That's the type of conservatorship that the court's going to insist on using for a person with an intellectual or developmental disability. And the thing about a limited conservatorship is, and this is where the term limited comes from, is you can pick and choose the areas of authority that you want to seek from the court, and the court can pick and choose the powers that it grants you. So it's a little bit more like the supported decision making. Remember where I had that slide with the list of powers that you could include, but you didn't have to include? This type of conservatorship works the same way. And I'll talk about the powers in a few minutes. And then there's something called an LPS conservatorship, and this is the type that's used for psychiatric care. This is the type of conservatorship that's required when someone needs to go into a locked psychiatric facility. And these can only be initiated by government officials. So family members can't initiate an LPS conservatorship, and I'm not going to talk any more about it today. It's a fascinating subject, but not why you all are here. So then with regards to general and limited conservatorships, we also have what we call conservatorship of the person and conservatorship of the estate. The difference between the two is that the person powers have to do with our kind of day-to-day living decisions, like who am I going to live with, where am I going to live, what sorts of services am I going to utilize. If I'm still in school, it has to do with educational decisions, medical decisions. It's all of those sorts of personal decisions, things that go to the person. Conservatorship of the estate is financial power. This would be the type of conservatorship that you would get if you need to control assets, wealth, property, bank accounts, things like that. Generally, I would say probably 95% of the families that we work with, we're only going to be seeking conservatorship of the person. Generally because most 18-year-olds don't have wealth, so we don't have assets we need to manage. And you don't need it for governmental benefit purposes. So if your son or daughter is going to be going on SSI, or if they're maybe already receiving Social Security through some Social Security program, those can be managed through a different process. You don't need conservatorship for that. So you're generally not going to seek estate powers. You also generally don't want estate powers in a conservatorship if you can avoid them, because you're putting all of your work and the finances of that person under the scrutiny of the court. And you're going back on a regular basis back to court to review all of those finances, and it's an awful process. So again, if you can avoid it, you want to try and avoid it. So if you have a disabled family member that may be getting some financial wealth in the future, make sure you plan for it accordingly, look at doing trusts and that sort of thing. Okay. As I've already mentioned, limited conservatorship is intended to be for people who have an intellectual or developmental disability. I think most of us in this room probably already know what that means. And generally, if your son or daughter is a regional center client, they're going to qualify under the limited conservatorship statutes. The definitions are very similar. But it's up here on the slide for you. I'm sorry, did you have a question? Oh, okay. Yeah, oh, I'm sorry, I didn't see you over there.
I may have missed earlier. Will you be speaking to the difference from general conservatorship?
Well, so I'm not really going to talk about general conservatorships because we're really focusing on limited conservatorships today. But again, the main difference between the two is that with a general conservatorship, it's an all or nothing sort of appointment. You don't get to pick and choose what powers you get, and the person being conserved doesn't retain any individual powers for themselves. Whereas with a limited conservatorship, you can bifurcate the authority.
So if someone had the intellectual capacity of a 2-year-old, would limited conservatorship still be appropriate, or would one be thinking general?
Yeah, it really just has to do with the type of disability. So if it's a person with an intellectual disability, like you're describing, then a limited is what the court is going to allow you to seek. They're only going to allow a general conservatorship in most cases if it's a person who needs conserving because they're having dementia or problems because of age-related cognitive decline, or people who have a mental health disability like schizophrenia or some other psychiatric disability. Okay, it's really just that's the distinction. And the court, even if you tried to seek a general conservatorship for someone who's a regional center client, the court's going to make you do a limited. Yeah, if you had done this 20 years ago, things were different. My sister actually had a general conservatorship when she was first conserved. Because, you know, my sister's in her 50s, so back when she was being conserved, the laws were a bit different. We still do see some folks who've been conserved for a long time with general conservatorships, but if you're conserving someone today, limited is what you need and what you're going to get.
How about other states?
Oh, other states are entirely different. So everything I'm talking about here today is California specific. And if you seek a conservatorship in California and then later move to another state, you're going to have to do the process all over again in the new state. So if you're thinking you're going to be moving in the near future, you might want to think about that before you invest the money to get the conservatorship in place here, because it's not going to be transferred.
What about SDOs? Is that transferred?
Well, again, kind of depends on the state you're going to and if they recognize supported decision making or not. You can certainly try using it in the new state, even if it's not, quote, statutorily legal. People use them in California even before we had our statute in place. But it's just a question of whether they're really enforceable if somebody were to challenge it. Yeah.
So after 18, what can you do? In terms of this, it said originally before the age 18.
Oh, no, it can, the disability, I'm sorry, we've got this bar across the top so you can't see. But this is just the definition of developmental disability under the code.
Okay, I know. It said originates before age 18. So after age 18, what can you do?
Yeah, if the person is over 18 and they have a disability that originated before 18, you can still conserve them. Yeah, that's what I meant, yeah. So the 18 age limit just means that the disability has to have been in existence, yeah. But the conservatorship can be done at any time. You can conserve somebody that's in their 60s, and they don't have to be 18.
That's what I thought.
Yeah, okay, no, sorry, yeah.
So the example would be like if you were in an accident and you were 19 and had a traumatic brain injury.
Right, exactly.
You're doing it general.
Yeah, so someone who has a TBI later in life, they're not going to be able to qualify for a limited conservatorship. Okay, the powers. I've been talking about how it's customizable. So the powers under a limited conservatorship, there's 7 general areas of decision-making that the court can grant to the conservators. The first here, select and control the residence. So it's pretty straightforward. Where is this person going to live? Who are they going to live with? All of the decisions about their living environment are going to be something that the conservator could act upon. Access to confidential information. This kind of goes to that disclosure question that we had earlier. This is going to also comply with HIPAA. So if someone's conserved and the conservator has the confidential records and information power, that's going to satisfy HIPAA requirements. They're going to be able to get medical records, all those sorts of things. Consent to marriage is another area. So whether someone can marry, whether someone cannot marry, this is an area of decision making that the conservator can seek and that the court can grant. Contract authority, this is about the only financial power that you're going to get under a limited conservatorship of the person. And this idea of contracting is useful. Sometimes it dovetails with the other powers. For instance, I had to sign the lease for my sister's apartment that kind of dovetails with the residential authority. But because I had the contractual power, I was able to effectively sign her lease. I can terminate credit cards if she were to somehow manage to get one. I actually had to do that once because she just got one in the mail. So you can do those sorts of contractual things for the person. Consent for medical treatment. This is a biggie. This is probably the one power that's most concerning to families when they first walk through the door. They want to make sure they continue to be able to make medical decisions and deal with doctors. Control of social activities and intimate relationships. This is a power that can be a bit controversial, as you can imagine. And this is the power that we most frequently see either families not request or we see the court deny. And this is, you asked a question about, do I see courts deny conservatorships? As I said, it's rare to see them deny the conservatorship in total, but it's not rare to see them deny this power. And oftentimes, in almost, well, I used to say 100% of the time, but maybe 90% of the time, the regional center, who's going to be asked their opinion about the conservatorship by the court, will recommend that a conservator not be granted the power to control social activities and intimate relationships. And if you think about it, it kind of makes sense. These are so intimate to the person. Is it really appropriate to have some third party controlling that? Again, in some cases it's probably appropriate, but you have to be careful about it. And we sometimes will recommend to clients to clients that they not seek it if it doesn't seem appropriate. Seeking control, education, and community-based services. So this is the power that you would be requesting if you want to make sure that you can continue to control school decisions if the person's still in school, deal with IEP process, all of that, or work with the regional center with regards to adult services and community-based services later in life. Okay. There's also a few things you can't do under a conservatorship, and this is regardless of whether it's a general or a limited conservatorship. You can't give consent for someone to be committed to a locked psychiatric facility. As I mentioned earlier, that's only available to the government, and it has to be done through a different type of conservatorship. You also can't give consent for treatment with experimental medications. This sometimes comes up about, can somebody be in a clinical trial and things like that if there's medical issues. So that's an area you need to be a little aware of, that there could be some issues there. No electroshock treatment. Again, that would be something that can only be authorized under an LPS conservatorship, not a general or limited conservatorship. No sterilization, reproductive decisions on behalf of the conservatee. I thought we had it, but you also can't authorize assisted suicide or euthanasia under a conservatorship. Yes?
I have friends who went through this with their son, and I believe they talked about religion. There was something about religion or just kind of monitoring or...
That's not one of the powers that is available under the conservatorship.
And was that, maybe because, they eventually left and moved to Oregon, so maybe it's another state. But it
Yeah.
was interesting that was one of the things that they said is very fun. I think the idea is that you want to be sure that the person that you're seeking conservatorship does not, join the cult.
Right.
Giving all their
Right.
funds to, religious-based institutions, and that's
I would kind of argue, at least the cult example that you just used, I would dovetail that in those social relationships in that power. To me, that would fall under that category. That might be a really good example of going to a judge and saying, this is why we need that power, even though you didn't give it to us before. The court will absolutely grant that power if there's some thing that we can point to see this is why it's necessary. Yeah, and so, occasionally, unfortunately, we might have a conservatee who is acting inappropriately, making sexual advances toward people, things, in those cases, the court's going to grant that power to the conservators, but it's just in the general run-of-the-mill case where there's no sort of behavior issues in the past that they're going to give a little resistance. Yes?
Does the contract authority apply to military recruiters or with selective service?
That's a good question. Actually, a person with a developmental disability does not have to file for selective service. So,
You had to sign up?
we go back and forth on this, but I think that there's a code that says they don't.
Yeah, I
Oh, okay, well, yeah.
I did it.
Uh-huh.
Just to cover myself, but I tried plus or
Right.
minus $1 million,
Right.
Who's trying to
Right.
do that.
It's an interesting question. So again, I've been told, and I haven't had a personal case, but I've been told that there is a statute, but I could stand corrected. So I don't know if I answered your question, but it's apparently an open area of the law. If something were to come up, I could certainly research it, but yeah, if you had a specific question. All right, conservators. We talked briefly about this a minute ago. So conservators can be basically any person over the age of 18. There's really not a lot that's required as far as eligibility to be appointed as a conservator, but you do have to be a legal adult. There are obviously certain groups of people that are given priority under the law, and that we give preference to immediate family members. So if there's ever a contest, if a parent is applying for conservatorship and an uncle is applying for conservatorship, the court's going to grant it to the parent. They have priority under the probate code. So families are always at the top of the list. Friends can also be appointed. Sometimes we have situations where that'll happen. Could be a family friend or something. Professional fiduciaries, care managers, these are individuals within our community that provide assistance and support to people with disabilities, and sometimes they will step in and serve as a conservator if it's appropriate and there's not someone else to do it. Regional Center or the Department of Developmental Services can also serve as conservator. They do it rarely, particularly in this area. I don't see Regional Center of the East Bay do it very often at all, but some of the other regional centers are more active in this area and will step in and serve as conservator. And then the place of last resort is usually the public guardian's office, and this would be a situation where you have someone who needs a conservatorship for some particular reason. It's become, the court has become aware of it. Each county has an office of the public guardian, and these are government officials who can be appointed to serve as conservator for people. They more frequently are working with individuals who are older and maybe don't have any family to help them in their old age. So normally if we have that situation with clients in the DD world, the regional center or DDS is more likely going to be called upon to step in those cases. Okay. You can also have multiple conservators. I think this went to the question we had up here in the front earlier. The statutes don't allow for a succession, and a lot of times I have parents that come in and they want to have, they want to be appointed, but then we want to say, well, but when we're gone, I want my son to step in or whatever. The court doesn't have a way of doing that. So what they can do is they can appoint all three of you. They can appoint mom and dad and son, sibling or something, and you can have multiple conservators. When you do that, all conservators have equal authority and power. So you just have to understand that, your other son or daughter or whomever is going to share power with you. Although on a practical level, almost always the people you're dealing with in the community don't really know that, and they're not going to require that all of the conservators act in unison. If there's one of you there at the time that a decision needs to be made, they're going to look to whoever's in the room, and that person's going to make the decision, and it's going to be implemented and be effective. So I tell people to not worry too much. Your son that's at college in Michigan isn't going to have to come back to California every time you need to take your other child to the doctor or whatever. It just doesn't work that way on a practical level. Yes? Uh-huh.
So me and my husband and our two older children
Okay.
are there, but our youngest child is over 18 finally. So is that an option to add her as well?
You can absolutely add people, and we do that on occasion for that very reason. Maybe we've got a sibling who was under 18 at the time. Unfortunately, to add someone, you do have to go back to court, and you have to file another petition with the court and go through a proceeding. It's not as long and involved as the original appointment was, because they don't have to reestablish the need for the conservatorship and all of that. But it is still going to require filing paperwork with the court. The court's going to do a background check on the proposed conservator and all of that, and then go to a hearing and have the court actually sign the paperwork. Yeah. So a little time and money involved, but yes, it can certainly be done. You can also remove people. So similarly, you can remove people. So if you have someone that was a co-conservator and they've now moved out of state and they're no longer involved with the person or something, you can always go back into court, explain those circumstances, and ask that they be removed. But again, it's going to require any change in the conservatorship requires an act of the court. It can't be done outside of that process. Yes.
Does this matter if there's no challenge in the sense, usually if I put myself and my adult disabled child's sibling or something like that, usually that person is not really that's not spending any time on it. So as long as whether it's 2 or 3, we do that to avoid the succession issue. As long as nobody's challenging it, just one person who's of those 2 or 3 can make decisions and there's no issue, right?
Right, that's what I was saying. So on a legal level, all of the conservators are supposed to act together. And that's what the slide is saying, that if you've got more than 2, it's supposed to be a majority decision. But on a practical level, if you're at the doctor's appointment with your son or daughter, I can't remember, and the other conservators aren't there, it's not like the doctor's going to make you call them up on the phone and consult. I mean, you just make the decision and the doctor will say, okay, great, and so forth. So yes, on a practical level, any of the conservators usually can act on behalf of the conservatee unilaterally. But on a legal level, the court expects that everybody is acting, as a group. Yeah, I don't know if that, it's one of these areas that where the practical application doesn't meet or match what the statute actually says. Yeah, but, I know, again, I use myself as kind of an example. There's only been one time in the 20-so years that I've been my sister's conservator where my father and I have had to act jointly. And that was actually when we signed her Section 8 paperwork for the government. They required that we both sign it. But every other decision that we've ever made, I've made it or he's made it, and we don't have to both be in the same spot at the same time. Okay. The other thing about having multiple conservators, it's a good thing. I got 15 minutes, thank you, is to know that it avoids a lapse in the conservatorship if somebody passes away. And this was the question I had from the back of the room earlier. If you've only got one conservator and that person dies, then your conservatorship's just been terminated. And in order to get a new conservator in place, you've got to go through the whole process all over again. We're back to ground zero. We're starting over with determining that the person lacks capacity and all those sorts of things. So you do want to particularly, if there's only one conservator and that person's starting to, get to where we have to think about what might happen when we die, you might want to think about adding someone, 1 or 2 more people, so that there's not a lapse in the conservatorship. Or, again, do planning ahead and make sure that there's a sibling or someone else that's in the mix when you set the conservatorship up in the first place, just so that you don't have that risk and you don't have to go back into court and spend more legal fees trying to change things. Because if one conservator dies and there's multiple, usually what happens is then it just gets picked up by the court the next time they do a review that someone's passed away, and they just kind of fall off. We don't have to do any sort of formal filing, usually. Sometimes the court will make us, but it's rare. Okay. All right, when to apply, we've already kind of talked about how 18 is like this magical age, and that's when you should sort of think about it if you can. I've also told you that in Alameda County, you're looking at probably about a 6-month process. So best timing would be to start talking with an attorney, if you're going to use an attorney to assist you with this, about 6 months before the 18th birthday. You want to get that paperwork rolling, get it filed with the court, so that you can then wait that window where the court's just kind of sitting there doing not a whole lot, waiting for the calendar to come up. And you want to try and have it so that the conservatorship is approved right at or just shortly after the 18th birthday, so that you don't have a lapse in time. Now, many people don't think about conservatorship, and so again, as I've mentioned, you can apply for conservatorship anytime after someone's 18. You don't have to do it at 18. You could wait until there's a need for it, but unfortunately you might find yourself suddenly in a crisis where you need it, you don't have it, and then we're running into court and having to get a temporary conservatorship. It's a more involved process. It's going to cost you more money. So it's always a good idea to kind of plan ahead and have it in place already so that when you need it, you got it. Yeah.
So this conservatorship, I thought is usually filed in the particular county where the person is living, right? So what is the impact of a signed document if the person moves from county to county within California?
That's a really good question. Okay, so yes, the conservatorship proceedings are going to be filed and are going to be handled by the county where the conservatee lives. That's another thing to keep in mind. It's always where the disabled person is residing that controls the conservatorship. And we sometimes have, the conservatee might be living in Alameda and the parents might be in Contra Costa or Marin or somewhere else. It's always where the conservatee lives. If the conservatee moves from Alameda to Contra Costa, odds are Alameda will keep it. They could send it to Contra Costa, because Contra Costa now technically is the venue, it's what we call it when it moves. The venue is now Contra Costa because that's where the conservatee lives. But my experience is that when the counties are close, usually the county who started it kind of keeps it. If, however, you've got somebody in Alameda and they move to San Diego, the court's going to kick you to San Diego. The conservatorship will transfer, and all of the paperwork moves from the Alameda County Court to the court down in San Diego, and then the San Diego court will start to monitor the conservatorship. Okay?
We have to revise the documents, or refile
No.
or revise.
You don't have to revise the documents because the conservatorship is valid throughout the state. So if you're just temporarily, for instance, on vacation in San Diego, you're down at the zoo, and the person falls and you got to take them to the ER, the conservatorship is going to work perfectly fine there just like it would here. It's just that if there's an actual change in the residence of the person, then the courts, because the court is going to continue to monitor this conservatorship. And so periodically the court will check in with the conservators, the conservatee, they want to go out and visit them. And so it's not effective for them to be able to do that across the whole state. And that's why I said if it's still local, if it's, a 10-minute drive up Highway 80, they're going to probably just keep it in Alameda. But if it's requiring their investigators to really travel to be able to see the conservatee, they're going to then insist that it be moved to the new county. On some counties, and again, unfortunately, counties vary, and the courts from county to county can vary in the way they do things, their procedures. Some counties will do that move automatically. In other words, if the court investigator suddenly realizes that somebody's moved and they want to move the venue of the case, they'll just send it to the new county on their own. Other counties require that you as the conservator file a formal court petition with the court asking for the move, even though they're the ones making you move it. So, you just kind of, again, you're kind of at the whim of the court, unfortunately. Okay. All right. Really quickly, I just want to kind of run you through the actual legal process of establishing a conservatorship, and I'll try and do this in about 5 minutes, Amy. She's watching my time for me.
Well, we have an hour and 15 minutes for the lunch and so.
Okay, well, I'll probably go over. I'll just tell you all, I always do. And I will take questions at the end, even if that means I'm here for another half hour. I'm happy. You guys can come and go as you want, so don't feel you have to stay if you want to go at the end of our time. The process, I think of the process of getting the conservatorship in place as kind of a 3-step process. The first step is preparing and filing all of the paperwork that's necessary to initiate the proceedings with the court. Because it's the court, everything is super paper intensive. There's a lot of paperwork. And there's about 8 to 12 documents that have to be prepared and filed with the court as part of the conservator, what we call the petition process. There's an actual petition itself, which is kind of the big document that says, we want this conservatorship, and these are all the powers we want, and this is why we need it. Then there's screening forms that have to be filed on behalf of each of the proposed conservators. That is going to include personal data and information about you as the person applying to be appointed as the conservator. There's going to be a whole bunch of background information on the conservatee that gets filed. There's a capacity declaration that has to be completed by the conservatee's doctor, psychiatrist, psychologist, someone with a medical degree. So yeah, there's a whole bunch of paperwork that has to happen. In our office, we have a paralegal assigned to these cases, and she does this paperwork day in and day out. She's pretty efficient at it. But even then, it usually takes our office about 6 to 8 weeks to do all of the paperwork and get all the input from all the people, get the doctor to fill out the capacity declaration. All those sorts of things have to happen, and then we package it up and we submit it to the court. So that's phase 1, is all of that paperwork preparation. Once it gets filed with the court, then we're kind of moving into phase 2, and at that point, the burden's going to shift from you and your attorney as the people filing for the conservatorship to the court. The court's going to immediately set a hearing date, and that date is going to usually be about, depending on your county, it could be as 3 to possibly like 5 months out from the date you file. That tends to be the range right now. And during that period of time, the court is then appointing a court investigator, which is a court employee that's going to review the petition, They're going to do those background checks on all the proposed conservators. They're going to want to come out and physically visit the conservatee wherever they're residing, interview them. They'll want to interview the proposed conservators. Sometimes they check with other family members or maybe a neighbor. They do a full-blown kind of background look at the people that they're about to be appointing. And then they write a report, and that gets submitted to the judge. And you, as the applicant and your attorney, will get copies of that report before the hearing, so you'll know what the court investigator has reported to the judge. There's also going to be an attorney appointed for the proposed conservatee, the person with a disability. In Alameda County, they use the public defender's office for that purpose. There's a couple of gentlemen that work in the public defender's office that do these for the county. Because they're the two that do it, we know them, we have a good relationship with them. So if you're working with an attorney that does these types of cases, they'll usually have a fairly good working relationship with the public defender. And they're similarly going to come out, interview you. They're going to want to talk with their client, the proposed conservatee, and then they don't usually do a written report, but they will appear at the hearing and let the judge know what their position and the person with the disability's position is with regards to the conservatorship. Usually, if there is an issue or concern on their part, they will alert the attorney for the petitioning conservators ahead of time, so you can try and sometimes work things out with them before you get before the judge. And then the third piece of the puzzle is that the regional center will be contacted by the court, and the regional center case management team will be asked to prepare a report that goes to the judge as well. And usually what that means is that they will put together, it's usually like a 2 or 3 page kind of letter, narrative, and they'll do a couple paragraphs of just kind of general background about the conservatee and their disability and kind of what their functional level is. And then they'll go through the various powers of those 7 possible powers we talked about earlier, and make a recommendation with regards to each power as to whether or not it should be granted by the court or denied by the court. As I think I mentioned earlier, it's very common for the regional center to recommend against the social activities and intimate relationships power. So we see that very frequently. Also, the marriage power is one that they sometimes will recommend against as well. I usually tell parents, if we have sought those powers and you see that rejection on the regional center's report, don't get too concerned about it. Just because the regional center is saying that they don't think it's appropriate does not mean that the court is necessarily going to follow that direction. The court's also going to ask the attorney for the proposed conservatee what the conservatee's position is, and quite honestly, the court is going to give that opinion and that position much more weight than they perhaps will give the regional center's opinion on that power. Yeah.
So can I ask you, if you have somebody that hasn't displayed any kind of behavior that the court would then consider that, but you know this person could be prey to, like if you see somebody that's a groomer and they target somebody because they know there's a little bit of intellectual disability, how do we protect them within this conservatorship against people who might?
Right. Sometimes that will come out, and sometimes that'll be talked about in the proceedings. Again, the court's not just looking at past behavior. That's certainly a factor, and if there has been some past behavior, that can be really powerful, persuasive information to give the court. But the court is also looking at the person's abilities generally, and the court's looking at, is this someone who can really effectively make a decision in this regard? Is this someone who is vulnerable to exploitation? Is this someone who may not be able to communicate well if there's something going on that others should be alerted to? There's a number of factors the court's going to look at and can be brought out in different ways. The court investigators will comment on things like that in their court investigation report. The attorney representing the conservatee will sometimes express concerns on those, on that basis. And I'll just say, it's not unusual for me to be in court with a client where the regional center has recommended against those powers. We may not have any, like, again, the past behavior sorts of evidence to point to, and I'll have the court-appointed attorney stand there and say, I've talked with my client, we have no objection to the 7 powers, Your Honor. And if that happens, we don't even discuss it. The court will usually just say, all right, they seem to be appropriate to me, I'm signing the order. Yeah, so I don't like to scare people, but I just warn people ahead of time that this could become an issue of conversation, and if it does, we address it. If there are really a need for the power, then we'll present that to the court, and usually the court's going to make a common sense, well thought out decision. Yeah, so don't worry. I tell people, don't worry about it too much. Yeah, don't lose sleep over it. Yeah.
Does the person need to be at that hearing?
Yes. The court likes and will sometimes insist that the proposed conservators as well as the conservatee be present at the hearing. Now, because of COVID, we're doing all of these remotely now. So what that means is that you're sitting in the living room at home with your computer and talking to the judge, but they oftentimes will want to actually even see it on Zoom, the proposed conservatee. And sometimes that works well, and sometimes it doesn't work so well. But yeah, they make the effort to make sure everybody's kind of part of the conversation. Now, the proposed conservatee's attendance can be excused a couple of different ways. If they don't want to appear, then the court's not going to force them to. And if they articulate that to their attorney will waive their appearance at the hearing. Similarly, if there's some sort of medical reason, or if it would be, disruptive for them, some folks that are on the autism spectrum, changes in their routine are not good, and so, making them appear at a court hearing could trigger behaviors. So in those instances, usually in the capacity declaration, the parents can have the doctor make a note of that, and if it's in the capacity declaration, then the court will excuse their appearance as well. But otherwise, generally, the court likes to have them there. Oh, sorry. We've kind of already talked about the review process, and then we all show up at the hearing. As we just talked about, the group comes to the hearing, and the judge usually is going to order the conservatorship that day. It's very rare for us to have a continuance where we have to come back later, but sometimes it happens. But usually that day, you're going to get the order. And then the letters of conservatorship will be immediately processed by the court with help from our office or the attorney you're working with. The letters of conservatorship is the document that you've done all this work for. It's the document that you actually will then show to whoever you need to show it to say, I am the conservator and I can legally represent this person and make their decisions and so forth. So the letters of conservatorship are what you want. And we're going to usually get you a couple of certified copies of those letters, and that's got the nice big embossed stamp, and that's what you would show doctors and folks at the regional center and all of that. Okay. After the hearing is over, the hearing itself as well is usually about 2 minutes long. It's not a big, it's not like TV. We don't bang gavels. Nobody gets sworn in. Unless you're in Los Angeles, they still swear people in there. But it's really informal. And usually the judge is pretty friendly. They'll just chit-chat. They usually will look at the public defender in Alameda County and just say, Mr. Plain, you have it, what's your position? And then he'll say, oh, this is a wonderful family, and I've met with my client, and they're very close, and I'm in full favor of the petition, and blah, blah, blah. And then the judge will look at me and say, counsel, do you have anything to add? And I usually say, no, Your Honor. And that's what you've just paid me a few $1,000s for. And then I say thank you. The judge usually signs the order, again, because we've done all the work ahead of time. We don't want to have surprises when we walk into the courtroom. And so if we've done the job right, we've got everything in order ahead of time, it's usually a very perfunctory appearance and hearing. But sometimes we have to wait around before they get to us, so you should be prepared to spend at least an hour, if not more, on the Zoom call meeting when we're doing it, because you could have to wait for a while, because you're not going to be the only ones on the calendar. There's usually a dozen or more cases that are all being dealt with at that same time of day. So just so you know, that's usually how the court process will work. After the hearing and you've gotten your letters, I mentioned earlier, the court's going to continue to monitor the conservatorship. So there's going to be a court investigator who is going to, about every 2 years, reach out to you. Actually, it's supposed to be every year now. This is one of the changes in the law recently. It used to be every 2 years they had to review. Now they have to review it annually. But they will periodically reach out to you, ask you what's going on. Have there been any changes we should be aware of? Is Jill or John still living at this address? It's just updating their records. Occasionally, there might be something that causes a red flag to go up, because they might, for instance, if the conservatee is living in a group home, they'll reach out and maybe want to talk to the group home manager. If there's some issue that gets reported, they might ask some more questions. But usually what happens is they'll just, kind of do a perfunctory review report. It will get mailed out to you, copy to us if we're your attorneys or whoever your attorney is, and then a copy goes in the court file. And usually their recommendation is that the conservatorship continue and there's really nothing for us to do. If though one of those red flags goes up, then you could expect to get a call from us, and we would say, we see this in the report, we think the court's going to set a hearing, and we'll talk about what we need to do to kind of address whatever the issue is. But again, that doesn't happen very often. Yes?
If you have a family trust on your home and, just a typical trust, is this conservatorship linked in any way?
No. This is solely a method of the court granting you authority to make decisions for your family member. It's not going to affect your personal finances or any of your estate planning directly at all. Now, obviously, if you've set up a trust for your son or daughter, that would come into effect possibly after you've passed. Whoever's managing that trust would probably want to communicate and have dealings with the conservator if it is not the same person already, because they'll need to coordinate things. But that's about the only connection between the two. Yeah. Okay. All right. I'm going to kind of skip through some of this because we've already talked about it. This is just going into a little bit more depth about the actual kind of paperwork process and so forth. And I think I've covered most of it already. Service is another issue I will mention, though. The paperwork that gets filed with the court does also need to be served on all of the immediate family members of the conservatee. And as you can see here, it's going to include spouse or domestic partner, if there is one, children, parents, siblings, and grandparents. So that's the group that we have to give notice of the proceedings to. And they're going to get mailed copies of the petition that's being filed with the court. And they're going to be told when the hearing is, so that if they have an objection, they can show up and let the court know that they object. There are no exceptions, as the slides say. So even if we have estranged family members, sometimes we have parents who aren't in the picture, or sometimes we might have a parent who's the grandparent, they're estranged. We still have to make every possible effort to find that person and give them notice of the proceedings. So you're going to be asked, when was the last time you heard from this person? Do you have the last known mailing address? What can we do to try and find this person? There's a whole process we have to go through. So the more you can help by having that sort of information available, the better. The court does take it quite seriously, and we can't just simply say, oh, well, we didn't feel like sending it to them, and they're not involved. The court's not going to accept that. So we do have to make an effort, and sometimes this can be a little bit of a problem. We've already talked about background checks and the written report from the court and the regional center, and the hearing being by Zoom. See, I did all the slides and I didn't even know it. Okay, and your letters and the general plan and the status report. Okay. I know fees. This is what I was trying to get to. Yay, everybody wants to know, what is this going to cost? So typically, if you're working with our firm, I can tell you what my experience is. I can't speak for other law firms, but I can tell you in our office, the attorney's fees for establishing a conservatorship from start to finish is going to run you between $3,500 and $4,500. That's kind of our range. We do charge hourly. So the more help that you can give us by having all of your paperwork organized, having those service addresses, for instance, that I mentioned available for us, helping us with the capacity declaration with the family doctor, all of those things will help keep the costs down. The primary generator of these fees is all of the paperwork we have to generate and file with the court. And then, just the appearance at the end, there's some time there that you'll get charged for, but it's mainly the paperwork and the service of all that paperwork that's generating these fees. So the more help you can be in that regard, the more cost-effective it's going to be. With regards to other fees, there are other possible fees, but we usually manage to get them waived for you. One is there are a bunch of court fees. There's a filing fee for the petition. There's fees for the court investigators' time to come out and do their investigation. But because the court is only going to look to the conservatee's ability to pay, and most of the time that person's, maybe getting SSI, if they're even getting that yet, they don't have the resources to pay for these things, so the court will defer those fees. There's also, that does also mean, though, that if there's outside resources like a special needs trust, sometimes this comes up, so if your son or daughter has a funded special needs trust, the court can seek payment from the trust if there's one available, yes.
Able accounts will be excluded.
Able accounts would not be included, yeah. I don't think the court's looking to drain people's able accounts for this. So anyway, that's the end of my slides. I'm 3 minutes over, I apologize.